Well, good evening, guys. Thank you for joining us. This is the 2015 Mid-Legislative Session Report of the Texas Homeschool Coalition. We're going to spend an hour tonight, is our plan, walking through what we are doing, the Texas Homeschool Coalition is doing, that is, in Austin. We have 7 people full-time in Austin. We have myself and Jeremy Newman, who's our Public Policy Director, and the 5 famous or infamous THSC watchmen. They have reviewed 9,000 pieces of legislation. We are tracking about 50 of those bills, and as you'll see tonight, some of those bills we are trying to kill. Some of those bills we have been willing to give language to alleviate our concerns, and then some of the bills we're trying to pass. So we're spending a good deal of man hours and dollars down there, and so we appreciate the homeschool community, and our goal tonight is to give you the breadth and scope of what we are working on there. So let's go ahead and get started. 2015 legislative session. As I mentioned, we have 7 people full-time, so we're reading lots of bills. We are contacting offices about concerns that we have, testifying on bills or against bills or for bills, and that is keeping us very busy. So let me begin by just covering some of the bills that we have opposed, bills that are on our opposition list, and as some of you may know, if you're familiar with the legislative process, very often a bill is filed and it may never even have a hearing. So the chairman of a committee has the authority to hear a bill or not hear a bill, to allow a vote on a bill or to not allow a vote on a bill. So that's the reason as we read through these bills, we separate them out into bills that we're for, against, and those bills that we do have concerns about, we initially go visit with the author or his office and lay out our concerns, and sometimes they're willing to address our concerns. That takes care of our problem. Sometimes they're not. So let's just look at some of the bills that we have opposed, and I don't think that this is not an exhaustive list tonight. We didn't want to spend time going through 50 pieces of legislation, but we're going to hit some of the high points. So HB 465 by Representative Donna Howard of Austin and Senate Bill 29 by Senator Judith Zaffirini. Those are not companion bills. I understand a companion bill is the same bill filed in the House and the Senate, but these are bills that are similar. And this really is an issue that deals with immunization. You know that that's been big in the news lately. Just had a news story today about a bill in California that they're essentially had a hearing today in an education committee who wanted to say that if you didn't get your kids immunized, you could not register in a public school. So there's a lot of blowback against that. But these particular bills are focused on the immunization registries. This is a registry run by the Department of Health and Human Services. 10 years ago, we fought a battle on behalf of parents to oppose. They wanted to make this an opt-out system. In other words, we're going to automatically put you and the immunization records of your children into this system unless you actively take steps to remove yourself from the system. And of course, as anyone would recognize, that is skewed for the government. So we were able to beat back that attempt and make it an opt-out system. An opt-in system where you actually have to actively say, I want my records to be involved in that registry. So both these bills would have changed the system to an opt-out system. We've opposed those because we, again, believe parents have a right to decide how those records should be used. We testified, I believe, against Representative Howard's bill, and those bills, at least at this point, are not moving. Representative Howard has another bill, HB 1674, that would force parents to consult with a physician before being able to get exempted from an immunization. And what we've seen is this law in other states essentially gives a doctor veto power over whether or not you can get exempted from an immunization. And we've seen situations already where we do not want to allow doctors to have authority over what a parent can or cannot do with regard to medical decisions for their child. So my understanding is that bill is not moving either. There's been a real serious pushback, not just from the homeschool community, but from parents across Texas and anti-vaccination groups. And so legislators who've made some positive comments about these things early on have recognized that this is not something there's public support for. So we opposed both those issues. We've also opposed, before I move on, Representative Jason Villalba has filed a similar bill that we have opposed as well. So there are a number of these vaccination-type bills that have been filed, and the good news at this point is those are not moving at all. Another bill, House Bill 2429 by Representative Vo, would allow a non-parent to consent for a child's medical treatment under the laws of another state without adequately attempting to contact the parent. So what we're seeing here is we're seeing a kind of a pattern of legislators who want someone other than the parent to be able to make parenting decisions for children. And so we have very clearly stated our opposition to that, because these are all efforts that would undermine the fundamental constitutional right of parents to make the decisions about the upbringing of their children. HB 1828 by Lucio in the House and Senate Bill 823 by Senator Rodriguez in the Senate are really bills. These are companion bills that were filed by the Family Law Foundation, and they are the opposite of what we're trying to do in terms of closing loopholes in the grandparent access statute and the family code that essentially allow grandparents of a single parent to sue for access, that is visitation or possession. And these cases have been used by parents who are vindictive, I should say in-laws who are vindictive and disagree with legitimate parenting decisions that people make. So this bill, the current statute requires that the only way a grandparent can sue in that situation is if there's a death, divorce, incarceration, or incapacitation. And in that case, the parents of that non-custodial spouse could sue the fit single parent for access or possession. And the case law requires that the grandparents have to prove that denial, actually the statute says they have to prove that denial of that access or possession would significantly impair the physical health or the emotional well-being of the child, and case law says that that has to be by expert testimony. Both these bills would dramatically change that statute so that any grandparent could sue any parent for access or possession, and that they would not have to have expert testimony to prove that. Jeremy and I spent 2 hours with a couple of attorneys from the Family Law Foundation, and they told us over and over that they felt like the current statute was too restrictive. And one attorney even said that 9 out of 10 grandparents that come to her, she has to tell them that they don't have standing under the current statute. So I take that to mean by her numbers that we would see a 10-fold increase in lawsuits by grandparents against single parents if this bill were able to move. So that bill, those bills are not moving. I really believe they were filed as a blocking action to prevent us from passing our bill. Josh has just reminded me. I just wanted to remind you, if you have questions you want to ask, you can post those in the question box on the right side of your screen, or you can send an email to thscwatchman@thsc.org. So thanks, Josh, for reminding me to do that. So anybody that has questions as those come up, email those to us or put them in the question box, and we will get to those as we get to the end here. Josh, I'm not sure that this Senate Bill 950 is by you, Rusty. Is that really true? I thought that was by Rodriguez. But this is another bill that would give the judges the right to refuse to recognize a child custody agreement between two fit parents. So very often in custody situations you have an agreement that is reached between two parents, and this bill would allow the courts to overrule decisions by parents in the course of a custody situation. I thought that was by Rodriguez, but it's also by you, Rusty. So you can see these are examples of legislation that really dramatically attempt to undermine the right of a parent to direct the care, control, and upbringing of their children. Let me move on now and talk a little bit about some of the bills that we have helped to fix. A couple of these are CPS bills. If you all have followed us, you know that we're involved in a lawsuit helping to defend the Tutt family, who in November of 2013, CPS came in and we illegally removed 7 of their children, and they've been working for a long time. They have all but one of the children back, and that child has been in foster care for a year and a half now. They had a hearing set for a jury trial in April, and that has now been postponed to June. So we've had issues with CPS for years, and that's the reason that we are very sensitive when HB 550 by Representative Price and SB 219 by Senator Schwartner. This is a 2,300-page bill that was brought by CPS, and they were basically saying this is really just a non-substantive bill. We're just trying to clean things up. And so our guys and others read through that, and we found a really substantive change that would have, had it gone through, told judges that they could grant any kind of temporary order without sufficient evidentiary requirements. So in a hearing in the Senate, we raised our concerns, as did several other people, and both those legislators were willing to accept language by us to alleviate that problem. And of course, Cecilia Woods, a family law attorney for us, that was able to give input. That I think an interesting thing about that whole discussion was that several of the groups that we work with came to the same conclusion that we did, and they basically said that we had more of a constituency, and while they see the problems, we have, because of our constituency, a better chance of killing that kind of legislation. And then another CPS bill is HB 2433 by Burkett, who is also the author of our parental rights legislation in the House, and the Senate companion is Senate Bill 206 by Schwartner. That's a 700-page CPS bill, and so the senator was open to our concerns. The bill has already passed out of that committee, so we're working with the House sponsor to fix our concerns when we get that legislation to the House. So both those legislators have recognized our legitimate concerns and are open to working with us to resolve those issues. Another problem, again related to immunization, is House Bill 212 by Representative Tony Rose. She had the same bill last session, and we raised our concerns about allowing 14-year-olds to consent to their own immunization with very loose requirements for parental involvement. She declined to work with us, and as a result of that, her legislation died last session. This session, she was very open to taking language about that concern and accepted that language. The interesting thing is we had another group who came to us and said, you know, we don't really like this even with the fix. And of course our point was, well, we believe it's resolved the issues from our standpoint. We encouraged her to go talk to the legislator, and as a result of that conversation, she was able to convince Representative Rose that the bill was unnecessary, and so that legislation was actually withdrawn. So let me talk now about some good bills that we have helped to draft, and what I mean by that is It is not uncommon for someone on a right-to-life issue or some of these, HB 1648 by Representative Damali White, for example, criminalizes and punishes anyone who forces or bribes a woman to have an abortion. And so when legislation is touching on parents or the parent-child relationship, because we have become kind of recognized as advocates for parental rights and those who are safeguarding parental rights, often these groups, legislators reach out to us and ask for our input. So we've worked with Representative Damali White to give her language. And then also Representative Jonathan Stickland has a bill to allow foster parents to homeschool unless it's found to be in a direct violation of a standing court order or federal law. And we really like that bill. The current CPS rule allows most foster parents to do that, which is a new change, but it's always better to have something in statute rather than a rule. So we've been glad to work with Representative Stickland on that piece of legislation. One of the other issues that we have been dealing with in the last few years is college admission. And about 12 years ago, we worked to pass a bill that would require state colleges and universities to treat homeschool graduates the same as public high school graduates for college admission. And prior to that time, many of the state universities did not see a homeschool grad as a college grad. They required extra testing. And so we were able to, in 2003, to pass a legislation requiring them to treat this the same. Unfortunately, in the last few years, they have been using the issue of class ranking to discriminate against homeschoolers. So what they do is they have a sliding scale, and if your class rank is lower, then you have to score higher on your SAT or ACT. And so a bunch of these colleges have placed homeschool grads without any justification in the third or fourth quartile, which means a homeschooler has to score 200 points higher than a public high school graduate in the same class. So that's the issue we were trying to fix. State Senator Charles Perry filed legislation for us that was SB 1543, and this just kind of lays out there what I've just mentioned to you, that there's a good amount of discrimination going on there. That bill had a hearing in the Higher Education Committee last week and was voted out of the bill, out of that committee unanimously, and is currently scheduled on the local and uncontested calendar in the Senate. So we expect, and essentially what that bill does is it says that colleges have to take the SAT score of a homeschooler and look at the average class rank of some other students with the same score and give them the average class rank of those people. So that bill, it looks like it's going to be passed out of the Senate pretty quickly, and then we'll be looking to find someone in the House to pick that up, and that looks like it's going to move without much opposition. This one is a big one we've worked on for, this is our fourth section now. We call it the Texas Parental Rights Restoration Act. It's House Bill 524 by Burkett in the House and Senate Bill 414 by Campbell in the Senate. And I mentioned earlier, as I was talking about the opposite bill, that what this bill does is it closes the loophole that allows these vindictive in-laws to really sue a fit single parent because of legitimate parenting decisions they may disagree with. So our goal is to make it more difficult for these vindictive grandparents to go after a single parent. We don't believe that your right as a parent should only be sustained if you have enough money to defend yourself in court. So this bill requires a preliminary hearing where the grandparents requesting access have to actually meet requirements outlined in the statute, and it requires the judge dismiss the case if the grandparents fail to meet those requirements. So what you often have happen is they file a case, and then it goes on for years and years with the goal of trying to run the parents out of money. So this also protects parents from frivolous or harassing lawsuits requiring reimbursement for legal fees as a result of these kind of frivolous cases. So the facts are that under current law, families can be ripped apart due to a lack of clear evidentiary standards in a part of the family code known as the Grandparent Access Statute. The interesting thing, I've had a number of legislators say they think this bill is an anti-grandparent bill, and my response to that is actually the Grandparent Access Statute is an anti-parent statute. And of course this statute is not meant to apply to abusive or neglectful single parents. So if someone is abusive or neglectful, they should file with CPS and under a different part of the code. So we're just trying to close those loopholes to protect innocent single mothers and their children. Jim Luce, a father in Tarrant County, was the focus of a lawsuit that we got involved in 2011. He lost his daughter for 3 years on temporary quote-unquote orders to the grandparents, and we got involved to help him, and after a jury trial, an interesting thing, in the jury trial, the grandparents argued that they should keep the child because they'd had her for 3 years. But ultimately, the jury ruled to return the child to her father. So that's just an example of what we're looking at there. I should mention that the very first time we were involved in one of these kinds of cases was about 15 years ago. We had a family in Odessa who decided to homeschool their 3 children because of their concern about negative peer influence in public schools. The parents of the mother were so vehemently opposed to their decision to homeschool that the grandfather actually physically attacked the father. And they did what most of us would do. They got a temporary restraining order, and the grandparents, as a result of that, filed under this Grandparent Access Statute and started a case that went on for several years. And ultimately, the parents went to the grandparents and said, you know, we can't keep doing this. How can we settle this? And the grandparents said, we will drop the lawsuit if you will give us custody of your daughter, and we will let you keep your 2 sons. And unfortunately, they agreed to that. And our point is, the family code should not be like business where the person with most money, the business with the most money, is the one most likely to win. And that's the reason we've been working to fix this statute, and we'll continue to do so. The encouraging thing is we now have, we got a fact page there at THSC.org, and we have a petition there that I hope you'll go sign to support the passage of the Texas Parental Rights Restoration Act. The good news is we have just learned this week that we have a hearing scheduled in the House on this bill on Wednesday, and we have a bill scheduled for a hearing in the Senate, Senate Bill 414, on Monday. So we have sent an e-blast out to members of the committee in the Senate where we think we need more help, and we're asking people to call those offices, encouraging them to stand with the thing. Now, the interesting thing is 2 years ago in the Senate, they had a hearing on both bills at the same time, the anti-parent bill as well as the Parental Rights Restoration Act. And the Family Law Foundation bill was so egregious. They got so many phone calls that 4 hours before the hearing, the chairman of the committee who was carrying the bill pulled it down. So I think it's interesting that this time the Senate has decided not to hold a hearing on that particular bill. So that relates to what I just mentioned there. Hearing dates next week on Monday and Wednesday. Appreciate your prayers on that, and if you have a legislator who is on one of those committees, I hope you will call and encourage them to support our legislation. And the Tim Tebow bill, HB 347 by Dutton and Senate Bill 391 by Burton, is a bill issue that we've worked on for probably close to 20 years. And what the bill does is it allows homeschool students to participate in UIL extracurricular activities through their local public school, the district school in which they live, or the district in which they live. Homeschool students can participate under similar eligibility standards as current UIL participants, but parents will have control as to how those standards are met. So specifically, the language is that in the first 6 weeks, A homeschool student would take a nationally normed standardized achievement test of the parents' choosing by a third party, and if they score at 50% or above, they would be deemed passing. And then each reporting period after that, the parent would simply sign a form or send a letter saying that their student is passing. This bill is permissive, that it is voluntary. It doesn't require anyone to do anything. And if people choose not to participate, nothing changes. We support this legislation because the foundation of our organization is that we believe parents have a fundamental constitutional right to direct the care, control, and upbringing of their children, and our position has always been that we think parents ought to have the right to make those decisions for their children, not the government. And we believe this bill expands parental choice by giving more opportunities for participation. And it would dramatically increase opportunity for homeschool students all across the state, but especially in rural areas. And we believe there's about a third of the homeschool students in the states that do live in the rural areas. The facts are that 29 of the states have done this with great success, and by that I mean that none of the states that have adopted this, and of course there are states from like Arizona, who is very, very free, like Texas, to the other end of that regulatory spectrum, like Pennsylvania, that is very regulated, who've adopted these kinds of bills, and none of those states have changed their laws for homeschooling to make it more restrictive. In fact, 6 of those states have enacted less restrictive means after passing these legislations. We use the term Tim Tebow after a homeschool student from the state of Florida who played because of a law allowing that in Florida, and he became a Heisman Trophy winner at Florida State, and of course he's pretty well known. Colin Klein is a football player from Colorado who was the 2012 Heisman Trophy finalist, who was also a homeschool student from Colorado. So those are examples of that. One of the things that we like to point out is that UIL was actually created by the state in 1913 for all Texas students. In 1915, eligibility, they changed their constitution to limit eligibility to only white public school students. So most people don't realize that the minorities, it was not until the late 60s that minorities were able to participate in UIL. They had their own league called Prairie View Interscholastic League. But interestingly, according to expert testimony in the Lambert case, at that time 90% of the students in Texas were being homeschooled. So when UIL changed their rules to limit participation only to white public school students, they not only were discriminating against minority students, they were discriminating against 90% of the students in Texas at that time who were being homeschooled. So we are working currently to move those bills. We're hoping for a hearing soon in the House and the Senate. We have a fact page on our website there at thsc.org/Tebow. And we have well over 4,000 signatures now on a petition to pass the Tim Tebow legislation, and there's a link there for that as well. So as I mentioned, we're working to schedule hearings on both committees. We believe we have the votes in both committees to pass that legislation. The same legislation we're pushing for passed the Senate last time with, I think, 21 votes. So with that, we've got, that's about 30 minutes, so we've got about 30 minutes here to open it up for questions. And I'm going to ask Stephen if he's got some questions, and if you still have questions, you can email those to thscwatchman@thsc.org, or you can type them in the question box on the right side of your screen. So we'll receive those questions, and we will spend as much of our last 30 minutes as we can answering those questions. So, Stephen, let me see if you have any questions for us.
So Josh asked a question about the Tim Tebow. He said, can home...
No, they cannot. So the UIL has a statewide rule that in order for a student to participate in UIL, they have to be a full-time enrolled student in a public school, and that is defined as attending at least 4 hours a day. So technically, a homeschool student, if they wanted to take 4 hours of classes at a public school, and the public school would allow them to do that, technically they could participate. But I am not aware of anyone or any school district that has actually pursued that approach. So the bottom line is no, at this time homeschool students cannot participate in UIL.
And on the topic of Tim Tebow bill, Kristen also asked, will independent school districts be able to opt out of allowing homeschoolers to participate?
No, I mean that is the reason that we are pursuing legislation is because we don't want to give the school district the opportunity to opt out. So the idea is if you pass a statute and it says that homeschoolers can participate and they can do so under these guidelines, then that's the guideline. It's similar to what we saw in the 1960s with the civil rights legislation. That was federal legislation that ultimately forced UIL to open up UIL participation to minority students because the federal law required them to do so to avoid prosecution for discrimination.
And Presley had a question about the TPRA, the Parental Rights Bill. How many people go through situations like what Jim Luce went through?
You know, the interesting thing about that is I don't know that we have any numbers. We have probably, I would say last session, we had 6 or 8 single moms who came to Austin to give us testimony, and we believe there are thousands that go through this. And of course, it's really hard to put a number on that. But just in since the legislative session started, we've been contacted by 2 other single moms who are going through this. And I think if you look at the reason that the family law lawyers as a group want this, if you just look at the Luce case, in that case, the grandparents, when they approached their attorney, he said to them, you have a very weak case, but if you're willing to spend more money than your son-in-law has, we can get you the child. And they ultimately spent about $400,000. Jim spent everything he had and $250,000 in that case. So I think it's pretty evident that this is about the money. I talked to my state senator who is a CPA, and that was exactly his comment, follow the money. So I can't give you specifics. I think if you go online and Google grandparent access in Texas, you'll find that there are hundreds and hundreds of attorneys who are willing to take those kinds of cases. So I hope that's helpful.
And also on the TPRA, Scott asked, would this affect how courts handle custody disputes? Does this bill deal with custody?
No, Scott, it doesn't. This issue is only related to grandparents who are seeking to file suit for access or possession against a single parent. So if grandparents are seeking conservatorship or custody, they would be filing under a different section of the Family Code, and this would not relate at all to a custody dispute between 2 parents.
And Raymond had a question about the ECO bill, the college admission bill. He asked, does the college admission bill allow homeschoolers to be included under the top 10% rule?
No, it does not. So that is an issue that is very controversial, and so no, it does not. So essentially what we're trying to do is get back to the initial intent of the original legislation, which was that state colleges have to treat homeschoolers the same way they treat public high school graduates for college admission. And what they have now done is they developed this whole class ranking, and because you don't have a class ranking, we're going to give you one, and they're using that to force homeschoolers to score higher test scores than someone with a equivalent test score. So, but it does not address the 10% issue.
And Conrad asked a question about the Tim Tebow bill. He asked, should homeschoolers have the right to participate in public school sports? And do you know why Louisiana's Supreme Court struck down their Tim Tebow law?
So I think as I laid out earlier, we believe that a parent should be able to make that decision, not the government. I think it's pretty obvious that, you know, we all pay taxes to support the public education system, and we just believe parents ought to have the right to make that decision. In fact, in our view, this is about freedom. It's about allowing parents to make that choice. So we think, in fact, I'll tell you a story about 10 years ago. I was talking, 10 or 15 years ago, I was talking to the director of UIL, and she told me, she said, Tim, if we did this, what you're asking, you would see a lot more parents homeschooling. And I think that's interesting that she recognized that if we gave people the freedom to make that choice, there would be more people choosing to homeschool. And we obviously think that allowing parents to make those kinds of decisions is a good thing. In relationship to the situation in Louisiana, I've just read a few news articles. I think the situation in Louisiana is a little bit different than Texas, in that in Texas, the University Interscholastic League has been ruled by the courts and the legislature to be a state agency. The association in Louisiana, however, is a private association. It's not a government entity, and I believe the reason the court struck that down was on that basis. But I do believe the governor is still seeking to make those changes some other way. But that's my understanding.
And then Scott had another question about the TPRA. He said, does this bill take away power from the court system?
Scott, what we're attempting to do in the parental rights situation is to limit the discretion of the courts. What I mean by that is we don't have a problem with the statute itself that says that the grandparent has to prove that denial of the access or possession to the child would significantly impair the physical health or emotional well-being of the child. What we have a problem with is that the process allows that whole thing to be circumvented. So a grandparent can file a suit, then they can begin a years-long process that avoids ever getting to that standard. And so what we're wanting to do is limit the discretion of the courts in those situations so that they have to adhere to the intent of the statute. I know some legislators I've talked to say we don't want to restrict the discretion of judges, and I just think that that's wrong. I think there are some poor judges, and I think the intent of this legislation was to set a high standard for grandparents to overcome the fundamental right of a parent, and when that process is allowed to circumvent the intent of the legislature, then I think we need to go back and fix that. That's what we're attempting to do.
Raymond had just a general legislative question regarding THSC and their efforts in the past. He asked, is the anti-parent bill that THSC killed last session being presented again? If so, is it expected to pass?
And yes, that bill was filed last session, again at the request of the Family Law Foundation, who opposes our legislation, and it has been filed again in the House and the Senate. The interesting thing is I believe that they really have no intent of passing that legislation. I think they filed that legislation as a technique. In fact, the Senate author of that bill told our guys that the chairman of the committee said that neither were those bills were not going anyplace unless we got together and came to some middle ground agreement. And I said, that's like saying to Texas Right to Life, you go sit down with Planned Parenthood and y'all come to a middle ground position. And I recently told Senator Campbell that I said, I don't have a problem with hearing our bill and hearing theirs. I'm happy for them to come defend this bill. But the legislation that they have filed was not put up for a hearing at the same time. And I think the reason for that is they recognize that it's an outrageous piece of legislation and they would get hammered if they ask for a hearing. So yes, it's been filed again, and no, I don't think it's going to go anyplace.
And then Lois asked a question about House Bill 2429. She asked what non-parent currently has authorization to consent to medical treatment. In other words, what is the justification behind this bill, House Bill 2429?
I think what they're talking about is situations where parents have left a child with grandparents or some other family member, and they can't find that parent to sign off on medical treatment. I mean, we've seen the same kind of thing last session filed for allowing non-parents to register or enroll a student at a public school. So you have a situation where the parent is not available, and so they're wanting to give some non-parent the authority to do some of those things. And of course, our concern is, you know, when you start giving non-parents the authority to make parental decisions, that's a slippery slope. So that's kind of the justification for that. And we've argued that obviously in those situations somebody needs to make that decision. We're just very, very concerned that we don't undermine parental rights, you know, based on a good intent that winds up having a bad impact.
And then Raymond asked about the Tim Tebow bill. Is it possible that the Tim Tebow bill will increase regulation on homeschoolers?
No, it is not. If you look at the legislation, the only requirement, and it is applied to those who choose to participate, and that is simply taking a national norm standardized achievement test. I would not consider that regulation. And again, as I often point out, the only way that in Texas we can be regulated by the state is for the legislature to pass a bill in the House and pass the same bill in the Senate and get the governor to sign it into law. That's the reason that we've got 7 people full-time in Austin and we're reading 9,000 bills and we're watching amendments, because we've been doing this for 25 years because we recognize any time the legislature meets, our freedoms are at risk. So what I'm saying to you is there's nothing in the current bill that would lead to the regulation of all homeschoolers. And every time the legislature meets, there's the possibility that someone would try to pass such a law. And I would have to say to you that compared to where we were 25 years ago, we have dramatic support for homeschooling and parental rights in Texas in the legislature and in statewide offices. So this is not about regulation or non-regulation. This is about freedom. And we've made the same sorts of changes when it comes to dual credit classes, college admission, all sorts of things where we've pushed the freedom for parents to make these choices and homeschoolers not to be regulated. So I hope that's helpful.
And then Conrad asks about the Tim Tebow bill. Does the Tim Tebow bill create a distinction between private schools and homeschools?
Conrad, that distinction already exists in state law. So the first time that we distinguished between homeschools and private schools in the code was in 2003, when we passed the legislation requiring state colleges to treat homeschool grads the same as public high school graduates. We used the term homeschool, and the reason we did is because a homeschool is a type of private school, but it's distinctly different. And we wanted it to be clear that we're talking about homeschool students and they shouldn't be discriminated against. In 2007, we passed legislation that requires the public schools in Texas to allow a homeschool student who lives in their district to take the PSAT test. And frankly, we passed that legislation because there were some public schools that said, we don't have to let you do that, and we're not going to let you do that. And that's the only place that some of these tests are offered. So in the course of moving that legislation, one of the vice chairman of the Public Education Committee said, well, Tim, you're going to have to include a definition of homeschool in the statute because I don't want the public schools to have to let every private school student take the PSAT. And so we went to Shelby Sharp, who was our general counsel and the lead attorney in the Lambert case, and we, with his input and approval, drafted the definition of a homeschool in Texas, and it's now in the Education Code, that relates to that particular piece of legislation, and that is very much tracks what the judge said in the Lambert case. So we have a definition of homeschool in the statute. It's been there for 8 years, and let me just tell you that one of the benefits of that has been that over the last 2 or 3 sessions we had concerns from legislators about these diploma mills who were claiming to be homeschools, who were selling diplomas. And we had several legislators come to me and say, we're going to try to pass legislation to stop that. And my response was, oh, well, that's okay, but I don't know how you're going to do that without impacting the freedom of homeschoolers and private schools. And if your legislation does that, we will vehemently oppose it. So they decided not to pursue that legislation. We argued that really the solution to those kind of situations was for the Attorney General to prosecute these businesses for fraud. And last year we were approached by the AG's office and worked with them. I gave testimony and was a consultant saying that these people, these businesses are not, they're not homeschools. And we pointed to that definition in the statute to say that by this definition it's not the parent who is doing this, there's not education happening, it's not enter through the home. And the Attorney General's office shut down one of these diploma mills, and so that was a direct result of having that distinction in the code. So I think one of the problems is that some people, 25 years ago, we didn't have the kind of support we have today, and homeschoolers were hiding behind the fact that we were private schools. But that has changed, and there are some distinctions. A homeschool is a type of private school, but it's distinctly different from other private schools. So that's a long-winded answer, but I hope that's helpful.
And Joel was asking a question about the ECO, the college bill. He asked, does this affect private colleges in Texas?
No, it only applies to state universities. So the state does not control or regulate private entities. So Rice University or SMU, they can have their own standards and requirements that discriminate against homeschools, and there's not anything we can do about that. So this legislation only applies to public institutions of higher education.
And then Tatiana had a question about the Tim Tebow bill. She asks, my question is about the Tim Tebow bill. By allowing standardized testing for homeschoolers who will participate in UIL sports, how will we keep the homeschool families from having to follow a standardized curriculum in order to be prepared for these tests?
I don't believe that you have to follow a standardized curriculum. My family, as we were raising our kids, did not pursue a standardized curriculum, and we used a standardized test all the time to ascertain where our kids were in comparison to kids all over the country in public and private schools. So I don't believe that a standardized test is like the state test that is tracking a particular curriculum.
All right, and then Scott asked a question about the TPRA. He asked, is this an
I lost you there, Stephen.
Scott asked a question about the TPRA. He asked, is this an anti-grandparent bill?
No, it is not an anti-grandparent bill. Again, I would just point to the intent of the statute is the grandparent can sue for access, that is visitation or possession, where they actually can take the child. But they have to prove that denial of that access would significantly impair the physical health or emotional well-being of the child. And so what we're simply trying to do is to say that the grandparent ought to have to prove that. That's what the statute says. They shouldn't be allowed to game the system and drag this process out until the parent is bankrupt and no longer able to resist the taking of their child.
And then Nita asked a question about our college admission bill. She asked, does Senate Bill 1543 only look at SAT or not, and not the ACT?
No, it'll apply to either. So essentially, whatever, most colleges will accept either of those tests, and so what they'll have to do is they'll have to take the test score of the homeschooler and look at that test score and then say what's the average class rank of the other students with that test score, and that's the class rank that they will have to give, whether they're using the SAT or the ACT. Good question. No.
And then Sybil asked a question about the Tim Tebow bill. She asked, don't you feel that THSC should not be pushing homeschools to be part of public school, but encouraging homeschool programs? Why not support homeschool organizations?
Well, I would say that we do support homeschool organizations, and we're not pushing homeschoolers to go to public schools. I think what I mentioned earlier was that I think if parents have the right to choose to homeschool and put their kids in extracurricular activities, what we will find is that there will be, and I think the UIL officials believe this too, there will be more people who homeschool. So I don't think it is an either-or situation. There are 29 other states that allow this. All those states still have homeschool leagues. And the reality is there are a lot of parents, I'm probably one of them, who would have chosen a homeschool team for my students because of the character and those issues that are important to me. But again, I believe that parents ought to be able to make that decision. 25 or 30 years ago, the Attorney General of Texas was saying he didn't believe parents ought to be able to choose to homeschool. And so it troubles me today when I hear some homeschool parents argue that we shouldn't let some parent make a decision related to the education of their children. So I don't think this will be detrimental to homeschool teams. I don't think we've seen that in other states. I'm pretty much a free market guy. I think you ought to let parents make those choices.
And we got another question about the Tim Tebow bill from Julie. She asked, did Mr. Lambert or others representing THSC tell legislators that Tebow legislation must exclude other individual private school students so private school teams won't lose players? Is this the reason that THSC will not lobby for an equal access bill to give every parent in a tax district the choice for his or her child to participate in tax-funded UIL?
Julie, we've not told legislators not to allow that. Senator Donna Campbell has filed the private school bill again. That bill is not moving. And I don't think, I think I'd refer you back to our discussion in 8 years ago when we were trying to pass the PSAT, and the vice chair of the education committee said we're not going to make this where every private school student can access this at the public schools. And I will tell you that that is still the attitude of most of the legislators. And here's the distinction, Julie. The distinction is that all the private schools have options. They are all part of leagues. Homeschoolers have been excluded from TAPS and these other private school leagues, as opposed to states like Florida. So we are simply trying to pass the best bill that we think it is possible to pass. We're not against private school students. There are other organizations that lobby for traditional private schools. But I can tell you, I know we've had this discussion and you disagree, but I would tell you that there is not support in the legislature for what you're talking about in terms of letting every private school student participate. So we haven't pushed that position. We're simply trying to pass something that would benefit the homeschoolers of Texas.
And Conrad asked a question about the TPRA. He asked, how does the TPRA help low-income single parents?
Well, I think, Conrad, that very often these single moms are low-income single parents. And what you have very often is the situation that I mentioned to you with the Odessa family 15 years ago, where they don't have the financial means to defend themselves in court. And so very often they're not able to resist the demands of these vindictive in-laws because they don't have the financial means to do so. So what we're trying to do is close those loopholes so that the grandparent can't use this as a legal weapon or a tool against that single parent to try to force her to do what they want them to do.
And Kristen asked a question about the Tim Tebow bill. She asked, how can there be an expectation that districts will not mandate a reimbursement from the state for homeschool students participating, such as has been done in other states like New Mexico?
Well, I can't say that the schools won't seek a reimbursement. I don't think they're going to get it. School districts have teachers' unions have a huge lobby, and the reality is, if you look at the number of students that we're talking about here, it's infinitesimally small. We had a bill several years ago in which the state we were going to give, I think it was $10 million to school districts to reimburse them for these students, and the teacher union still opposed the legislation. So I was on a talk show with a guy, and we were talking with a teacher union rep about this, and she was out here talking how desperate the school districts are for money, and yet they were willing to forego $10 million because they didn't want homeschoolers to be able to participate in UIL activities. So that whole issue, again, it's like any other legislation. They can come file the legislation. I think they're going to have a hard time justifying the amount of money they're looking for based on the number of students we're talking about.
And David asked another question about the Tim Tebow bill. He asked, does the Tim Tebow bill undermine the Leaper case?
No, it does not. We reached out to Shelby Sharp, who was the lead attorney in that case and has been our general counsel. Some argued that would actually be the case, and Shelby responded in writing to us, and we quoted him on our fact page that this bill would not impact Leaper at all.
And Elliot asked about the legislation that THSC is pushing in general. He asked, how can we help THSC get these bills passed?
That is a great question, Elliot, and one of the things I would encourage you to do is to follow us on our Facebook page, get our updates, and just follow what we're doing. We just had our last Capitol Day where we had 300 homeschoolers there. And just be aware of what we're doing, and if you're supportive of some of this legislation, the parental rights legislation, the Tim Tebow legislation, the college admission legislation, or anything else we've discussed tonight, pick up the phone and call your state rep or your state senator and talk to their staff and say, you know, this is very important to me. I hope you guys will support this. And it's amazing how few phone calls can have a terrific impact on a legislator. So any of those things that you see that are important, make sure you're getting communication from us and develop a relationship with your state rep and your state senator. Great question.
And our last question is from Sybil about the Tim Tebow bill. She said and then asked, she said, taxes are to be used for education. So she asked, do you feel that you are perpetuating the abuse of tax dollars?
I don't believe we're promoting the abuse of tax dollars. I think those tax dollars, Sybil, are already being used for UIL, and we are simply asking that the parent of the homeschooler gets to choose whether or not to participate in an extracurricular activity. And I would simply go back to the initial founding of UIL in 1913. They had a debating club and a sports league, and their goal was to offer these activities to students to enable them to become better citizens of the state of Texas. And I think that is a laudable goal. And I'd also point out that as a result of those tax dollars, there are far more activities and opportunities through UIL than there are otherwise. So I don't think that's a misuse of tax dollars at all. I just think it's an opportunity. Again, this is about freedom. We believe parents ought to be able to make these decisions. We pay taxes to support those situations, and we think that would be a good thing. So I want to thank everybody for joining us tonight. We're happy to continue to answer questions if you guys have others. We're also going to, this session is being recorded, so we'll post it someplace online. I'm not sure at this point where that will be, but we'll publicize that so folks that didn't get to listen tonight can listen, and we'd be happy to address any questions that anybody else has. So,
Tim, we did have one more question come in, if you would like me to read that, and then also I was told to remind everyone that we will be posting the recording of this webinar at thsc.org/townhall.
Okay, thsc.org/townhall. So that's going to be on our website, and I'll be happy to take the last question.
This was from Joel. Joel asked one last question about the Tim Tebow bill. He asked, do any homeschoolers actually want equal access to extracurricular activities?
I think so. I think that's the reason 4,000 people have signed our petition to pass the Tim Tebow bill. In our hearings during the last session, supporters versus opponents were like a 5-to-1 margin. So I think it's pretty clear that that homeschoolers in Texas want equal access to these activities. So, Stephen, unless is that it? Any more questions?
That is all I have, sir.
All right. Thank you guys for joining us. Feel free to reach out to us. Pass this on if you want others to listen to it, and we'll be happy to continue fielding questions if y'all want to send those to us. Thank you guys so much, and have a good night.